We're going to bring on our next panel to the stage. Ryan David Williams, Andrew Jewett, Marc Boiron, Matt Miles, and Marshal Webb. Moderated by Amy Wan. Thank you.
All right. Hi, everybody. My name is Amy Wan again. I'm going to be moderating this panel, but before I do, I just want to give everyone a quick chance to introduce yourselves. If you can just tell us in 30 seconds, or go down the road, tell us who you are, what your company is, what you do. Can we start?
Yeah, so my name is Marshal Webb, and I'm the co-founder of Path Network, LLC. We are a token for distributed network monitoring that has been in place since the last 5 months.
How you doing? I'm Marc Boiron. I'm a partner at FisherBroyles in Orange County. We have about 240 attorneys in the firm, about 20 of them focused on the blockchain space. I've been in this space for about a year and a half now. I'm basically advising on companies on all blockchain-related issues, most of them, ICO-related.
I'm Andrew Jewett. I'm one of the co-founders of Aperture and Property Coin. We are a residential real estate investor, and we are actually doing an I'm not saying ICO anymore. We're doing an STO, security token offering.
The evolution.
Yeah, exactly. Right. We're done. See you later. So that's it.
Good morning, everyone. My name is Ryan Williams. I'm an attorney, founding partner at a law firm, Experience Legal. We're based in San Francisco. We represent exclusively tech startups, and about 90% of our work these days is in the blockchain crypto space. Background in securities law in New York. Moved to Silicon Valley, worked with tech startups. That kind of Venn diagram kind of led me to blockchain. So we've been doing it for about 2 years now, doing about 5 or 6 ICOs. They were ICOs at the time. And my view on it now is different than it was 6 months ago, 6 months before that. It'll be different 6 months from now. So if you're like watching this on that video somewhere, whatever I'm about to say is going to be entirely wrong when you watch it. But I'm looking forward to kind of sharing that evolution of at least my thinking on some of these topics with everyone this morning.
Hey, good morning. I'm Matt Miles, also one of the co-founders of Aperture. I just want to add to Andrew's intro that Andrew and I were formerly investment bankers specializing in asset-backed and mortgage-backed securities.
All right. Well, Marc, we keep seeing each other at all the panels in LA. And I think over the past at least year, we've seen a lot of evolution on the securities front, right? Back in the beginning of 2017, this was the wild, wild west, and everyone thought these were unregulated, and now we know that they aren't. Can you give us maybe a quick rundown of just what the environment and the ecosystem has been like from a securities perspective for maybe like the past 3 months?
Sure, I'd be glad to do that. So we go back to, probably the easiest time to start is the SEC's subpoenas in February, March, is really when the environment started changing. And personally, my approach to ICOs is no different than it was 6 months ago. I think there's a certain, almost everything's always been a security, and there's a little room for having something that's not a security. But the environment in the U.S. from an investment perspective has actually changed probably more than anything else. And that is simply that you're not really going to raise much money in the U.S. right now. It's just a tough market. Bottom line is you have, and a lot of them are based here, some of the syndicates, some of the funds, who used to be able to pool tons of money and you'd be able to raise funds from them, those have really dried up because of the SEC's actions. And so you've got this kind of situation where you've got the SEC kind of handing out those subpoenas. At the same time, you had these platforms that were starting to evolve where you see things like Securities, Harbor that were kind of coming about right around that time. You hear more noise about T0 and Templum and Open Finance in terms of regulated exchanges. It's all kind of coming together towards these security tokens. The interesting part in this environment, though, is that you really don't have any successful security token offerings that aren't straight up, equity securities of like venture funds or something of that nature. Pretty much everything, you know, there's a couple that have raised maybe $15 million, but nothing significant. And so bottom line is you see the shift towards the STO, but I don't think that the investor base is actually ready for that yet.
Ryan, you mentioned earlier that your thinking has evolved considerably and seems to keep evolving every half year. Can you give us a quick rundown of the evolution of that line of thinking?
Yeah, sure. I mean, I was probably slightly hyperbolic, but you know, I think it's interesting. Only in kind of the blockchain space can we talk about like how a body of law has evolved in a 3-month period, right? I mean, it's like that's where we start is kind of phenomenal, but and says a lot about just how quickly things are moving. And we also have to keep in mind that these are international kind of multi-jurisdiction issues as well. So we're not just talking about the SEC, we're talking about securities regulators all over the world, and we're not just talking about securities regulators, right? And so there's just kind of so much, and there's tax implications. I mean, I think in many ways, the securities law issue, because I think it was fairly clear, was in many ways kind of a red herring that kind of distracted a lot of the conversation early on. But what I think, if we kind of go back from that 3-month period and look back at kind of the first SEC proclamation about an actual issuance with the Dow in July of 2017, everyone at that point started rushing. My phone started ringing off the hook, and everyone said, "No, I have a utility token. This new thing was invented apparently called the utility token. I have not found it anywhere in any kind of legal, any place that would have a legal consequence or significance."
I think it was coined by Lee Schneider. I think.
Yeah. Well, and it really caught fire because everyone saw the Dow, right, which was this, we talked about it, this decentralized investment vehicle into kind of dApps built on Ethereum, right? And so it was kind of, and there was a return of profit. It was so clearly a security. It was kind of the low-hanging fruit, the natural place to start. And everyone said, "Oh, well, mine's not a security, mine's a utility." And so we had that kind of craze run rampant until from about July till December. And when Munchie came out, I think on December 11th, and the SEC basically said, Munchie was, for those of you, I don't know kind of like how much context people have here, but Munchie was essentially a food review app platform that was going to issue tokens to redesign its platform onto the blockchain. And he was going to allow users to, if you left a review, you got rewarded in Munchie tokens. Restaurants could reward their loyal customers in Munchie tokens. You could then redeem Munchie tokens to buy food, right? So this is utility. But the SEC, for a variety of numerous reasons, one of which was the platform wasn't ready yet, but it wasn't the only reason they stated, said, no, listen, you can have utility, there can be some utility concept here. If you're selling it as a security, if people are buying it with the expectation of profit based on your efforts, whether it has some utility or not, it's a security. And the orange grows in how we had utility too, but people weren't buying them for the orange juice, right? So then you kind of start. So after that, you started everyone saying, "Oh, I got a utility token, and mine is live. My platform's live," as if that was like the one dispositive fact in this whole thing. It's live, and it's a babysitting app in the United States, and I'm going to sell it to a bunch of crypto whales in Japan who have no children. It's like, wait a minute, where's that utility again, right? Or why are they holding $10 million worth of babysitting credits? And so. And I think what you're seeing now, and so now take us into kind of early this year, I think where kind of Marc started us off, and the SEC is kind of throwing a lot of water, I think, on the space, especially a lot of these kind of, oh, I'm a utility, I have some basic functionality, therefore I'm not a security. And what we're seeing now is either what are truly securities, right, kind of tokenized common stock or asset-backed securities, which these guys can talk much more eloquently about than I can, or you see people actually doing things to tokens like rationally tying their holding limits to like how much you'd actually use that platform, right? So I can look at your average usage over the last 6 months, say you've used it X number of times. If I can only hold 150% of X, perhaps I'm now kind of limiting speculation. Or I have some clients who just aren't letting you, if you're a US person, you can't cash out your tokens, right? There's no exchange, there's no liquidity, or they're a stable value, ways to basically ensure or really prevent speculation. And that's, I think, the evolution from I can sell whatever I want to I'm a utility token to I'm a utility token, but I'm live to, oh, shoot, I got to really actually make this thing not an investment opportunity. I can't wink and nod it. I think that's where we are now. So I think maybe, sorry, that's long-winded, but maybe it's more as I've seen not much has changed in the tokens themselves, but the kind of participants, the industry, the expectations I think have been evolving very rapidly, and we as practitioners kind of need to keep up with those market dynamics that are changing, even if the law has been fairly well established for about, I don't know, 80 years.
So I want to ask the founders on this panel, because I've heard a lot of very interesting things lately. Everything from founders of US blockchain companies are moving to other countries and taking their teams with them, to the interesting, like, okay, we're going to start up Cayman foundations and all this stuff for geographical regulatory arbitrage, to we're not going to sell in the US at all, to maybe we should go back to traditional equity offerings, or our tokens are going to represent equity in the company. What are you guys seeing in the ecosystem today, especially for US founders of blockchain companies?
And I'll start. For us, it's a little different, right? We are a real estate fund, so there are very well-defined rules that go along with real estate in the U.S. It's funny you mentioned Cayman, because we actually are issuing a Cayman entity, but that's more because we are following the kind of well-trodden rules of issuing real estate funds in the U.S. One of the things that we did all along was we said, Matt mentioned we were former investment bankers. We looked at the ICO world back in the summer of 17 and said, my God, these are securities. We see real estate. There are a few real estate backed ICOs that were saying, oh no, you use our token to invest in, use the platform to invest in deals that you choose, but our token itself isn't a security. And obviously we said, that's not the case. But we all along went down the path of issuing a securities token, and I think, frankly, it's been a real challenge in just trying to figure out the ever-evolving regulatory landscape, but also, how do you sell this thing? Because that in and of itself is a roadblock. The SEC comes out and says one thing, and everybody says, oh no, I'm going to go do this other thing. But we've kind of always been on that kind of straight and narrow path. I mean, we'll talk a little bit about this in our chat in a half hour or so. But we actually presented to the National Association of State Securities Regulators, or NASA, not the space NASA.
Three A's in there. So
Yeah. And we want to be super forthright. Like I always say this when we get interviewed. Like, I like living in California. I like living in the U.S. Like, I don't want to go to jail. I want to do this thing the right way. So I think there's a lot of people that have been trying to go around securities regulators, and I heard somebody say recently, it's the Ubers and the Airbnbs of the world were fighting the taxi medallion regulators and the housing regulators. You pick a fight with the SEC, you're going to lose. So that's my take on it. Matt probably has different views, and I'm sure you probably have different views too.
Just to elaborate a little bit, I mean, all the things that you mentioned are considerations that operators have to think about, right? So, in part because it's a well-worn path for real estate issuers, real estate fund issuers, and in part because it's an extra layer of protection we issue out of Cayman Islands, right? Should the SEC care a little bit less about what has happened in our Cayman Islands issuer? That's one theory, right? The other thing that we thought about is, do we just ban U.S. investors? I mean, the hope from our standpoint was, let's not do that, because we have a product which is supposed to be very understandable to U.S. investors. We want to market ourselves primarily to institutions and accredited investors, but the lack of a clear pathway has not been comforting as an issuer.
Yeah, so I'm going to jump in here real quick. So, as the co-founder of a Nevada-based LLC, I mean, the regulatory ambiguity has been stifling, to say the least. One of the best things that we've seen so far is try to stay as compliant as possible and be proactive. So one of the first measures that we took was we picked up a CEO who had a background in kind of leading the way on regulation. So our CEO was one of the gentlemen that helped define the PCI DSS standard, and we felt that this was a good decision to try to find similar compliance in the blockchain space and try to jump in front of things before they can occur.
You know, one of the great ironies I think about this space is that there's such a huge magnifying glass on ICOs, TGEs, STOs, whatever you want to call them now, right? That they are uber compliant, right? To the extent you are going to go out and do it, you know, legal is one of the questions that everyone asks at, is the first to ask, you know, and now it's, you know, have you done AML? Have you done KYC? Do you have counsel in every single country in which you're selling? Are you in compliance in every single country in which you're selling? Whereas traditionally, for a startup that's just going to go raise regular money, you know, you're going to do a quick and easy, you know, Reg D offering. You're probably not going to have a PPM. You just have some angel investors, maybe a VC fund. Maybe if you take some offshore money, it's like, it's all kind of, it's very informal, right? And no one's really doing crazy AML, KYC, and documenting all of it. And for an ICO or TGE or STO or whatever you want to call it, it's so much more expensive. So do you guys have any thoughts on that?
To us, just from our perspective, it was worth the investment to jump in and put forth the effort in following and being compliant, just for the peace of mind to get these procedures in place. And although as you stated, the cost is significantly more, I think it far outweighs the penalties that could come up later down the road.
Yeah, I actually think it's one of the most interesting things about this space is the way firms have gone overboard. I think a lot of firms had a very aggressive position, you know, late last year, and then basically just went way overboard now. In that you could take something that like simply operates in a platform and never leaves the platform, couldn't possibly leave the platform, and half the law firms are still saying that's a security, and they're just so conservative about it. So I think that's one thing that shift and doesn't necessarily make sense. The other part is it's been kind of interesting to me that when you look at what I'll call equity tokens, the concept that an equity token is that complicated and legally that there's so much ambiguity there is kind of a little bit of amusing, because an equity token is literally, at least take a Delaware corporation, literally all it is equity, which we've been selling for many, many, many years, that literally just gets tokenized to be put so the stock ledger is on the blockchain. And Delaware has said the stock ledger can be on the blockchain. Why is that so complicated from a securities law perspective? It's not. It's just an offering of equity that is going to be on a stock ledger on the blockchain.
Taking back on that, if I can, it's like when we went from paper stock certificates to, you know, PDFs and or on like e-shares or Carta now, right? Like it's just that change. It's where that data is recorded has changed, and no one like blinked an eye at that. Right. Now this is like terrifying.
But now you should spend 10 times more on legal.
Yeah.
Oh, I mean, as an issuer, I mean, we definitely feel as though there's a magnifying glass, you know, under, you know, scrutinizing what we're doing, and we feel a kind of an obligation to, you know, really, really perform the right way. So I agree, and actually, you know, the kind of, I would say the initial costs relative to the issuance have ballooned. But I want to mention one other interesting thing, because, you know, it's the part of the interest to us as an issuer is the ability to tap a market of investors that you're never going to otherwise access, right? And so that was attractive to us as issuers when we launched this project, notwithstanding the extended time, the time and cost extensions beyond what we anticipated. I'm still glad we're on this path, and I think it, you know, nonetheless will, you know, has brought a lot of attention to us and what we're trying to do, and so that's been helpful. And I think, you know, we're excited about where this environment goes.
Yeah, just one kind of funny anecdote to what you were saying before is, you know, this is distributed ledger technology is at the foundation of everything we're all doing in this room, right? And when we, as a fund issuer or an equity issuer, or whatever you want to call it, putting assets on the blockchain, we get the question all the time: why blockchain? You know, what do you need the blockchain for? And again, it's
and
just
this isn't a new blockchain project,
yeah,
et cetera, et cetera.
It's just funny because, you know, I think you're starting to see the evolution of this is people thinking, okay, we need to put assets on the blockchain, we need to put stocks on, we need to put bonds, we need to put all sorts of different things on the blockchain, Yet we still get the question from I think, the hard line, the purists of, this isn't a new blockchain. Why are you guys doing this? But
And
it's evolving.
Yeah, and just it's funny because if you think about something that literally is a company issuing equity, somebody like us issuing an asset-backed security, we have the purest form, the simplest possible form of blockchain, and which is somebody's giving us money, and we're using blockchain to record that they're an investor in this thing. And yet, as Andrew mentions, the blockchain purists, we get a lot of questions like, "This isn't a new blockchain project. Why should I care about this? Why are you doing this? Are you trying to be cool? Trying to get notoriety for yourself?" It's very interesting, and the amount of pushback you get. Who's your developer? Did your securities audit? It's a simple Ethereum token that is as simple as it could possibly be for the purpose.
Let's talk a little bit for a second about the international arena, right? Because someone mentioned that now, if you want to go do one of these token offerings or raise money somehow for tokens in the U.S., that environment has chilled significantly since last year. What are we seeing internationally? Is it still a very vibrant funding ecosystem? Are international regulators caring and starting to put out guidelines and frameworks and launching enforcement actions?
Yeah, no, I guess I'll jump in here real quick. As far as what our perspective has been on this, we really have seen a lot of interest internationally. I think that some markets, especially in the East, are definitely still very interested in this space.
Yeah, I mean, I'd say clients can raise a ton of money in Asia. Is the bottom line is there's a ton of capital there. They're not interested in, not bashing security tokens. They're great. I love them actually, but they're not interested in security tokens in Asia. They're more interested in them here than they are in Asia. I just had a client who came back from meeting with a lot of top executives of like exchanges and things like that actually invest in ICOs, and every single one of them said, "I'm not interested in touching a security token." What it's worth pointing out from a pure legal perspective is the concept that, and I'll try to keep it short, Reg S is what everyone looks at as U.S. people or U.S. companies. So the first approach that everyone takes with Reg S is they say, okay, I'm going to set up an international entity. Now I am a foreign company under Reg S, and so because I'm a foreign company under Reg S, I fall under Category 1. There's 3 categories, Category 1 being the most lenient one, and now basically I have to put no transfer restrictions on my stock or on the security or anything like that. And the answer is, if you've got a majority of stockholders that are still U.S. residents or citizens, so going ahead and moving offshore doesn't help you, and your business is principally administered outside of the U.S., a majority of your assets are in the U.S., or a majority of your executives and directors are in the U.S., one of those 3 need to exist, then you are still going to be considered a domestic person, in which case you're going to fall under Category 3, in which case if you consider yourself as having an equity security, which is very broadly defined, you still have to put a 12-month transfer restriction on the security that you're issuing offshore. And so the fact that companies are going offshore, really, in most circumstances, when you're talking about U.S. people, it literally makes no difference because you're going to have a 12-month transfer restriction just the same way you would under Reg D.
What's going to be the impact of all of this for the industry, for the U.S.? I mean, from my perspective, maybe you might get a little bit of brain drain, or I think what you might start seeing is, internationally, there's going to be a lot of innovation for blockchain, tokens, those sorts of things in the U.S. because of the chilled funding environment. We might fall behind from a patents and innovation, creating a new industry perspective.
Navigating these waters as a U.S.-based startup certainly was difficult and expensive, but we feel that what we've learned as we've studied the compliance and put forth things into action was that in the end it helped the company. It made us aware of the state of legalities in the U.S. and it really helped to shore the business up. I think it was the right decision.
Yeah, and I think it's going to bring a whole level of legitimacy to this industry. The people who are able to weather, I'll call it the storm, but it's not. That's the wrong word. But getting through this kind of uncertainty with regards to the SEC and how the oversight of this industry is going to change, I think you'll start to see a lot of the best practices from kind of the old world transfer over to the new world. I think we will fall a little bit behind currently, but it will catch up.
Yeah, I almost think in an ideal world, an issuance out of the U.S., might become a stamp of legitimacy, right? Because you were subjecting yourselves to all the regulatory regime. But I will say that present day, if you had two identical projects, identical teams, identical quality of marketing, et cetera, and one is offered from Gibraltar or Switzerland or wherever, and it's a utility token instead of security token, that project's going to raise significantly more money.
So I have a question for Marc and Ryan specifically, although you guys feel free to chime in. I know Marc and I at least agree that although the vast majority of token offerings today really are securities, at least the way they're being done, that there still is theoretically room for, a pure utility token that is not a securities offering. Ryan, I don't know if you feel the same way. What are some of the features of what that theoretical pure utility token might look like, and how that offering would need to be conducted?
Yeah, well, I absolutely agree that the SEC has been, I think, very intentionally careful to leave that theoretical possibility open. And I think it can be done. I think it's not, if you read between the lines in Munchie, it's not really just what you sell, but it's how you sell it. Yeah. And Amy, you kind of hinted at this, and so I think it's not always so much a problem. You could even have that perfect utility token right now, and you sell it in the wrong way, with kind of priming this expectation of profit based on your efforts, and you're going to have a problem. And so I think there's kind of two buckets of things you can kind of do. And I'm seeing more and more clients coming to me with really taking kind of real substantive steps and trying their best to fall under this umbrella. Keep in mind, we've been told what a utility token isn't. We haven't been told yet what it is, and so keeping in mind that caveat. I think there's two ways to kind of do it. One, you kind of take away the efforts of others prong by kind of waiting until you're actually launched live and try to mimic like a Bitcoin type scenario, right, where it is actually kind of being mined and there is no kind of offering of it and there is no fundraising of it. Or you look at things. You limit kind of the expectation of profit prong of the Howey test, which I'm not going to get into because everyone has read about it ad nauseum. And you do things like I mentioned before, right? If you somehow rationally limit your holdings to what your actual use is of the platform, that could be potentially strong evidence that you're actually trying to limit speculation and investment opportunity. If you say, hey, you can only use it on my platform, right? Like you can't cash it out, you can't exchange it, you can't transfer it for anything else. You got a Visa prepaid gift card, and now you use that Visa prepaid gift card within my ecosystem, and that's it. That's something else you can do. So that's kind of on the how do I limit, how do you actually be desirous and indicate to the SEC that you actually desire preventing investors and speculators and people who want to buy your token for the expectation of profit? How do you keep them out of your ecosystem? And when I tell most clients, or over the last 6 months, to tell clients the kind of things they had to do, they would say, well, Ryan, why would anyone buy my token then? I'm like, that's the point and the problem, If
why
you
even
can
have
do
a
it
token?
for something else, let's talk about it. So yes, the possibility's there. I still listen to people when they say, I need a utility token opinion because I'm very hopeful that I'm going to find that really strong use case and I'm going to be able to do it. It hasn't come yet, but I'm hopeful. So talk to me if you think you have it, and we'll see. So.
Yeah, and I mean, to build on, I agree with all those points. And the way, people are achieving that, there's a few different ways. One, you're seeing more dual token models, right, where you've got a pure security token on one side with the hope that you can raise funds that way, and then you've got a utility token. What that two-token model looks like, whether it's, some say, you've got a security token that mines utility tokens and they receive the utility tokens, or you've got some that'll say, hey, we'll have a security token that we actually sell, then we'll create a stable coin. Well, creating a stable coin is really expensive and really hard, and nobody's really created a good one that actually is backed by probably something. And then you've got, you've got the concept of a similar idea as you create a security token, then you issue a token that's what I'll call tied to the platform in the sense of you code it so that whenever you first transfer it, it's a transfer to the platform. I don't actually believe that you need to continue to have it operated only within the platform as long as that first transfer is to the platform, because they can only use it for consumptive purposes in that case, and they don't actually have an expectation of profit. So there's kind of those specific ways to do it. Look, there's still probably an avenue where somebody's very, very careful in the way that they market this, where they say, look, our token is simply a piece of software that we are selling. And anything that we sell to the public, any public statement that is ever made, sells this straight up as a piece of software. And then we've got these investors who are buying some kind of instrument, and that instrument has some kind of discount, and they're expecting a profit on that discount themselves. Literally that instrument, not on the token, on the instrument itself. And that the world only views this, and the only expectation of profit the world has is none, because they are literally buying a piece of software. And I think that there's a way in which companies could very, very, very carefully market a token so that it's not a security. What I also think is that 99% of them are going to fail halfway through, because they're going to say, one of their advisors is going to be like, we're going to the moon on Telegram, and you're going to screw it up. And so most of them are going to do something stupid. But if you're really disciplined, there's probably a way to actually have it.
Not just like your advisor, someone's been on your half, but you go into these Telegram groups and all your supporters are saying when moon and when Lambo, and then you're like, no one wanted to make any money, I swear. It's just kind of, in retrospect, going to be a really difficult thing to do, and you don't even control that. And so I'm always on I'm on Telegram with all my clients, and I'm telling moderators, like, shut this down. Like, there's no moon, there's no Lambo. I don't know what those things mean. And you got to be really proactive. It's not just you. It's really hard.
Yeah, no. So it's a good point. This is really interesting because I follow all the Telegram channels and all the social media channels of my clients, and I've got one client who's just fantastic at this, and I've told them very clearly what to say. And bottom line is, they've got a whole Telegram channel, and they sell mostly privately, and their whole Telegram channel says, why would I ever buy this thing? I can't make money off of it. And I'm like, save, 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 save. It's the greatest Telegram channel ever, because like literally everyone's like, I can't make money off of this. And I'm like, this is perfect.
So the great irony of all of this, and I didn't even learn this until a couple months ago, or I didn't delve into this a couple months ago. But so my husband is really into like Nike Air Jordans. And so apparently what Nike does is they have all these tiny mini releases of these like limited edition, different colored Air Jordans that people go to the store and they line up for like overnight, whatever, and then people buy them, and I'm like, oh, so you wear them, right? No, they don't. They save them as this collector's item, and then there's this whole app that you can download for your cell phone that's basically like a whole Nike Air Jordan exchange. And I'm like, how is it that all these tokens are like, very much securities, and the SEC's all over them? And I'm looking at these Nike shoes, and there's a whole exchange over it, and Nike just, they put them out, and they just look the other way. So I find that incredibly ironic.
So is the next like phrase "when Jordan," or is it like?
We have about 8 minutes left. I want to be able to take a couple questions. Do we have any from the audience? Yes.
So we're looking to go more for ICO, and one of the debates is onshore offshore raising, and we've heard a couple of friends of ours who got screwed on the French because they can raise money onshore, also went offshore, and couldn't complete all the KYC paperwork. So do you have any views on we're defaulted to either raise 100% on 100% off?
From our perspective, we're doing the same KYC for everybody, and it's really, really challenging. We're spending a lot of money, and a lot of people start the process, and we can see it. We can see where they get really skittish in our processes and the data that we're collecting. They stop. I'd say it's, maybe 10% make it all the way through?
Yeah.
Maybe?
Yeah, that's
5%?
one of the critical differences between current days and a year ago.
But it's really challenging. and you have to do it. One of the things that we were advised was you not only have to do your AML on the customer itself, the person buying it, but the coins that they're sending to you. Where did that come from? And do a blockchain analysis on that. Was it on the Silk Road? Was it anywhere in any sort of like, you know, was it part of the Bitcoin or the Ether that was stolen? You know, you really in these days have to be super careful because you're right. You can get tripped up and have to give all the money back.
Sorry, we're trying to keep it to one question per person. You had a question?
Yeah.
Yeah.
Why there hasn't been a thoughtful pushback against the SEC? And I see, because I notice a lot of people trying to get around the rules. And instead of that, because blockchain is not like putting files on PDF, stock certificates on PDF. It is immutable. You can trust it. The data is there. There is transparency. There is a lot of difference. So I think there needs to be a very thoughtful, because the current laws do not.
So, excuse me, sorry, what's the question?
Yeah, why there hasn't been a thoughtful pushback against SEC?
I think it's not so much pushback against the SEC as it is there's a lot of the community that is sitting there engaging the SEC and trying to educate them on our particular perspective. But you know, to Ryan's earlier comment, I think it's not so much to say that blockchain is like converting something to a PDF, except the point he was trying to make is that these tokens, you know, to the extent that they are securities, we used to have paper stock certificates, then we had electronic stock certificates. This is just, you know, it can be a stock certificate in a different form. It's just a digital form that happens to be a token, but we're not actually saying anything about the technology itself.
And what?
Oh yeah, thank you. So I'd just like to add, you know, a lot of these regulatory bodies are in a very tough position, you know, and we did see a lot of rampant abuse, you know, over the last year. I mean, it was the market was very unstable. So I do feel that, you know, it's not like we've seen an industry-wide ban on ICOs. You know, I think they just really want to try to weed out the bad ones.
Yeah, I'd say, honestly, I think the SEC's approach has actually been, given the case law that they're dealt with, they've done, I personally think they've done a really good job. They've been smart about it. They've thrown water on the industry instead of shutting it down. There's only one area in which I really have a problem with which they're handling it, and it's Reg A+. Because they're stalling any, you know, Form 1As that are filed there, and that's really the avenue that, if you want a security token, you should be looking at right now. Now, that may very well be that they don't want liquidity in a market that doesn't have a regulated exchange, and so why would we approve something that has to trade somewhere that isn't regulated? But at the same time, it's kind of like they just do, it's fishing expeditions for them. It's like, let's learn about this industry through Reg A+ offerings. So that hasn't been good, but overall, they've been shutting down the fraudulent stuff, giving kind of a heads up on stuff. I think their approach has been completely reasonable.
Do we have it? Oh, okay, many questions. Charles.
I'm going to ask the security question because I don't think that based on experience when we went from paper certificates to digital ledgers, it made zero difference to companies because everyone was already on book entry. And when we went from T+3 closing to T+2 closing, it made no difference to investors or issuers. So even admitting that blockchain is just the next evolution of digital ledgers, and eventually probably all stocks will be on blockchain, why should I care as either an issuer or an investor whether a share of stock is tokenized or not, and why not wait a year or two until it's just the norm?
I think you probably shouldn't. I think that's exactly what we're dealing with right now as issuers. You know, we go to the kind of structured finance conference every year in February in Las Vegas. There's 7,000 people in the traditional structured finance world. And when we told them what we were doing, they said, that is so cool, so fantastic, I can't buy it. And when we asked, well, why not? Well, they don't have the mandate, and I don't know what it is, and I can't explain it to my compliance person. I can't explain it to my credit department. I think we're super early in this, where you know, you're right. In a year or 2 years' time, when this becomes much more mainstream, it shouldn't matter. it should look like you know, the DTCC or the kind of the Bloomberg terminals of today. I think you'll see the blockchain shift into that world, and it just will be the way everything's traded.
And I think it depends on what you mean by security token, right? I mean, if we're talking about a share of stock of, you know, Class B non-voting common stock that's been tokenized, for example, that's one thing. If you're talking about a cryptographic token that like actually powers a protocol, its own blockchain, its own DAG or something, that is its own thing. You actually need that token to exist to power this thing. And what we're talking about in that case is not a share of stock on the blockchain, but it's a cryptographic token that we're treating as a security. And so I think even the term security token is not a monolith. It could be a share of common stock that's been tokenized. It could be an asset-backed security. It can be this cryptographic. It can be what it is, a cryptographic token. But because the way in which it's being sold, it needs to be treated as a security. And so I think we just got to be careful not just to say security token and assume we all mean the same things. So I think for everyone up here, it probably means something slightly different based on kind of who they're working with or how they approach it.
I'd also say that I think there's a bigger impact that the blockchain is going to have on equity securities than moving from paper certificates to uncertificated stock, for the simple reason that, so like two very well-known examples in Delaware, for example, was Dell Inc.'s merger. So I represented Dell in that merger, and one of the things I went through in the appraisal proceeding was all of T0's demands for appraisal, that every single one of them got kicked out, which was 70% of the appraisal class, for the simple reason that you had one of the 12 intermediaries that misclicked a button and said, we are voting in favor of this merger instead of against the merger. Suddenly everything's kicked out. That just doesn't happen. You have your own decision when you are the record holder of the shares. Go look at Dole Inc., the banana company, when it did its merger going private. There's a whole case that talks about this in the Court of Chancery in Delaware. And there was something like, I don't know, 10 million extra votes that were voted based on the record date being set and shares moving in every direction in again, the 12 different, you know, street names that it was being held in. That just doesn't happen on the blockchain. And I think that is a major difference and a very good reason to have, you know, tokenized equity.
Okay, I think we probably have time for maybe one more super, super quick question. Probably someone from the middle, gentleman in the back.
Thank you.
Quick.
So I was wondering, if a token is trust minimized, is it less likely to be classified as a security? Like, if it's entirely trustless, is it, you know, less likely to be classified as a security if you know, did an ICO for such? Kind of links to his question over there, in that the point of the blockchain is really to minimize trust and risk for, you know, customers and sellers and intermediaries. So, you know, that's really my main question, because if a token isn't trust minimized, then it's kind of just a replication of a stock, you know, without any real, you know, new anything. You know, the blockchain, what it really provides is that minimization of trust. So just wondering how that correlated to securities.
I think in terms of whether or not it's classified as a security, trust is not necessarily something that the SEC is not a factor that they consider, right? It's, you know, what does the token represent? It's the Howey test, it's all the case law, and it is how is it sold? Do you guys have anything else to add? Great. Do we have time for one more question? Okay, yes.
Yeah, that was what you said, and you just said the same thing. What distinguishes how it is sold? The SEC review it as a security or not.
So
how do you sell it so it wouldn't be?
So the question is, how do you sell it so that it wouldn't be?
Okay, this is an example of a token that's probably a security. Buy my token today and you'll make $1 million by tomorrow. I mean, like, you know, and how you're selling it is as an investment opportunity versus, you know, selling it in a way where you're limiting to maybe only purchase people who actually would use your platform can use it, right? For example. And so it's really all comes down to, are you selling people on an opportunity to make financial gain, or are you selling them on an opportunity to purchase a right to use part of your software?
I think one good example is look at Kickstarter, right? If I'm going to make, I don't know, a standing desk on Kickstarter and raise money for it, and I say, hey, if you put $500 towards my campaign, I'll give you the first edition of the standing desk. Well, people don't necessarily sit there and order 100,000 standing desks, right? They order one, right? And they're not expecting to necessarily sell that standing desk for $10,000 more than they paid for it. It's a lot of little details like that.
I always tell clients, if you want any hope of having a utility token, there's two statements that you absolutely have to make, and then there's a ton of other things you need to not do. First statement is not, when somebody says, are you going on exchange, it's not, we're thinking about it, it's not no comment, it's not, we can't answer because of legal issues, it's no, we are not going to list our tokens on exchange, and we will not help anyone list our tokens on exchange. Number two, the question is, can we make any profit off our token? The answer is absolutely not, because we are focused on shareholder value, and the token is a way for us to monetize the business, just like selling an iPhone. And so, that's it. Now, the truth is, no private investor cares when you make those two statements, and they actually prefer that you make those two statements because they're smart enough to understand it. But there's also a whole host of other things. For example, this is literally there shouldn't be a document in the public world that looks anything different than Microsoft's Word license and a brochure to Microsoft Word. That is essentially what your token should look like. And if you're going to go beyond that, you're probably selling a security in most cases.
All right, so it's 11:05. I think we've gone a little bit over, and so give it up for our panelists.
Thank you all so much, and thank you also to Amy Wan for moderating. Thank you. There you go. There it is for Amy.